I'd like to call to order the December 4th, 2025 Planning and Zoning Board Local Planning Agency meeting. Can we get a roll call, please?
Yes, sir. Chairperson Kakwama.
Here.
Vice Chairperson Michael Ferranti.
Here.
Board Member Rachel Hood.
Here.
Board Member David Macon.
Here.
And Board Member Louis Halal.
Here.
Beautiful.
All right. Can we please stand for a moment of silence and the pledge? Please face the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right. Any changes to the very short agenda today?
No, sir, not that I know of.
Okay. All right, opening it up for public input. Seeing and hearing none, we will close the first public input and go to the consent agenda for the approval of the meeting minutes from November 6th.
I make a motion to approve the meeting minutes on November 6th, agenda item 300.
Okay,
Second.
you have a motion and second.
Beautiful. Chairperson Ma.
Aye.
Vice Chairperson Ferranti.
Aye.
Board Member Hood.
Aye.
Board Member Macon.
Aye.
And Board Member Halal.
Aye.
All right. Moving to the public hearing agenda, item number 400.
Good evening, Chairman, board members. For the record, Carolyn Roll, Director of Community Development. Item 400 is ordinance number 2025-17 for an amendment of Chapter 20 of the Land Development Code, specifically pertaining to establishing a process and procedures for applications for reasonable accommodation from the Land Development Code, as well as for the allowance of certified recovery residences within the city in order to comply with Florida Statute 397-487. I can answer any questions you might have, as well as Assistant City Attorney Ike regarding this item.
Okay. Any discussion? Questions? I do have a question. I'm trying to understand the definition of a certified recovery residence. I assume that this would not be congregate care or assisted living facility, or would it include those uses?
So that's the certified recovery residence is specific, so it would exclude those items. That you can
Okay.
Those types of care homes.
I can provide a little bit more context on the ordinance if you like. The legislature adopted a bill the last session that requires the city to adopt an ordinance that allows or creates a process for reasonable accommodations for certified recovery residences. Recovery residences are essentially, you probably may have heard them referred to as sober homes. They are places where people who are recovering from drug and alcohol addiction are living in a residential setting. To give a little bit of background, recovery residences themselves, I think, were popping up quite a lot, especially in South Florida. And it was becoming somewhat problematic there are places where there were instances of, fraud or even human trafficking and abuse and things going on because it's a vulnerable population. And so the legislature did do some studies and things and created the process to become certified. That process is fairly rigorous. You have to, the residents has to annually renew their certification. it has to be actively managed as well by a certified recovery residence manager, essentially. There are different levels of certified recovery residences depending on the level of supervision that the residents have. But, again, we are required by state law to create this process to allow for those that are certified, and the ordinance is clear that we are only going to provide reasonable accommodations for those that are certified to locate essentially in single-family neighborhoods where they would otherwise not meet the definition of a family under the code. In addition, this ordinance does go, I would say, beyond what the statute required on certified recovery residences, because the city has really always had, or for many years now, had the requirement to follow the Americans with Disabilities Act and the Fair Housing Act and provide reasonable accommodations for people with disabilities from our land use and zoning regulations to the extent that was necessary to allow them to use and enjoy a dwelling. And so when tasked with this for certified recovery residences by the legislature, we just kind of went above and beyond that a little bit to formalize the process for asking for reasonable accommodations, which again, we always had the obligation to respond to under those laws. So this ordinance, the process that's created could be used for other types of reasonable accommodation requests. A classic kind of example is like if someone needed to, for example, have, let's say, a ramp that was in a setback, right? In order to use their dwelling, they could ask for a reasonable accommodation to encroach in the setback without having to get a variance or some other, do some other process. And these reasonable accommodations don't run with the land. They're specific to the individual or the group that's offering the service. So they don't, once the property turns over, they don't, continue on with the next owner. The process is not, there's no public hearings involved in this. The Certified Recovery Residence Bill did provide that we needed to draft the ordinance in a way to have as few public hearings as possible. And so the process will be that they will apply to the community development director, and if necessary, there is an opportunity for an appeal to the city manager. And of course, that makes sense when you're dealing with requests from people with disabilities. You don't necessarily want to have a public hearing to discuss, their private matters. So, so again, this is creating that process, sort of formalizing what the city has really always had an obligation to do anyway. Yeah, if you have any other questions, I'm happy to answer them. I just wanted to provide a little bit more context about why we were bringing this, and the legislature set a deadline to do this by January 1. Will be second reading will be slightly after that, but we're on track to meet essentially their deadline. So
Okay. Yeah, no, that's very helpful. Thank you. Without knowing what the rigorous certification process was, I was concerned that it opened up abilities for a broader range of like congregate care or assisted living facilities to be able to tap into variances that they otherwise wouldn't have. On Section 20-455B, it read, as far as eligible applicants, it did include or a provider of services to disabled individuals. So that's why I didn't know if it covered those types of other uses.
I mean, again, this will only extend to any group that the city already would have had an obligation to provide reasonable accommodations to under the ADA or the FHA.
Okay,
So,
all right, thank you. Any other discussion, questions?
I've got a question. Can these residents be established in places that have homeowners associations?
yeah, it's a good question. So the statute, I'll get to the actual language here. So, and the bill that was just passed does say that the application of this section, which talks about certified recovery residences, does not supersede any current or future declaration or declaration of condominium, any cooperative document adopted pursuant to Chapter 719 of Florida statutes, or declarations of covenants adopted pursuant to Chapter 720, which deals with HOAs. So this law, again, it doesn't supersede any HOA covenants, and any reasonable accommodations that the city grants pursuant to this process doesn't affect HOAs. And so to the extent that, let's say, a certified recovery residence wanted to be located in a neighborhood that had covenants, they would need to also seek accommodation from the HOA as well. I mean, I don't represent HOAs, but I mean, I can tell you that HOAs are subject to the Fair Housing Act, and there may be an obligation, separately under the FHA for them to provide reasonable accommodations to allow recovery residences to locate there. But the city's ordinance does not affect that. And the state statute doesn't impose any obligations on the HOAs independently.
Okay. Yeah, they've held up several times other court cases where they're ruling that they're single family. And their definition of family, that gets into play a lot, but they
Yes.
usually win those cases. So you can't just open up a house and say, we're going to have a boarding place.
Yeah, I mean, again, there's a lot of case law about reasonable accommodations for especially recovery residences or sober homes, and seeking accommodations so that they can locate in single-family neighborhoods. And for the most part, that is typically required under the FHA and the ADA. People who are recovering from addiction are considered disabled under those laws. So again, there's always been sort of this obligation. Now, this ordinance, with regard to sober homes in particular, or recovery residences, we're limiting the city's obligation to provide accommodations only to those that are certified. And that is, again, based on the fact that there's quite a lot of legislative history and so forth about the importance of being certified. Any state agencies are not permitted to refer individuals who need to go into a recovery residence to anything other than one that is certified. They will only make referrals to certified recovery residences. So, and the process, they're going to have a good neighbor policy. They have to have specific policies about how to deal with residents that relapse, eviction procedures. They have to have quite a lot that they have to provide to the state in order to become certified.
That's all I have.
Is there, I guess, does this apply to just existing residences, or does it include new construction or redevelopment?
Yeah, it would be, so we have included in here as well that there are some zoning districts that we're allowing as of right, that a certified recovery residence could locate there. without seeking any reasonable accommodation, generally where we allow multifamily. But yes, I mean, this would apply to any residence, and if it's new construction, once it's built, obviously, there could be a request for, let's say, an LLC that's running, a certified recovery residence to use that home as a recovery residence, and again, essentially get an accommodation or essentially a waiver from the requirement that it is a family as defined in the code that must live there.
Does it allow for, like, construction of accessory dwelling units to be used?
So the ADUs that would be very unlikely. I mean, just because these recovery residences, typically you will have, somewhere around 6 residents. So it's just not, it's not a feasible, like, economic model for these to come and want to locate in an ADU. We do have restrictions, but I mean, I suppose, again, they could seek a reasonable accommodation, but I suspect that would be very unlikely because they just wouldn't be able to fit,
And they're being
a
monitored.
number of people in that ADU. Yeah.
Right.
Anyone else? Okay. Then just as a formality, I will open it up for any public input. Seeing and hearing none, we will close the public input, and I will ask for a motion.
I make a motion that we approve ordinance 2025-17, reasonable accommodation from the city's land development regulations and certified recovery residences.
I'll second it.
Roll call.
Alrighty. Chairperson Ma,
Aye.
Vice Chairperson Franti,
Aye.
Board Member Hood,
Aye.
Board Member Macon,
Aye.
and Board Member Halal.
Aye.
All right. Great. Moving on to reports. David, any report?
No reports.
No reports.
Okay.
No.
None.
All right. Opening it up to the final public input then. Seeing and hearing none, we will close final
Oh.
public input.
Shoot.
Oh,
I did just want to review something really quick with you guys before we end,
Yes.
just because our schedule remains the same except for January of next year. And so I just wanted to bring to you guys' attention that your following or your next meeting is January 8th and not the 1st, because we will be closed. Every other meeting next year for you guys, it remains the same. It's the first Thursday of every single month. I just wanted to bring that to your attention, though. It remains at 5:30 unless you guys have any qualms with that.
all good. Thank you.
Okay, I just want to bring that to attention.
Thank you. And with that, we are adjourned.
All right. Happy holidays, everyone.
Happy holidays.
Yeah.